My name is Severina McGill and I teach Human Rights Law at Jindal Global University. This module will look at marriage and divorce laws under Hindu laws. After this module, participants should be able to understand the difference between personal laws and secular laws. It will enable them to contextualize the Hindu Marriage Act of 1955 within its legislative and political history and analyze the body of Hindu law that is applicable to marriage and divorce of Hindu people. The module will help in understanding the elements for a valid Hindu marriage and recognize the difference between a void and voidable Hindu marriage. The participants will also be able to recognize the grounds for divorce under Hindu law and understand the difference between divorce and judicial separation. India is a diverse, pluralistic country and home to people of different faiths. The Constitution of India recognizes the right to one's religion and the right of everyone to be able to preserve everyone's culture as some of the fundamental rights of an Indian citizen. India's plurality and diversity has manifested itself in its laws. Marriages and divorce in India, as well as other practices such as inheritance, are governed either by personal religious laws or by secular laws. Personal religious laws may be defined as the body of laws which apply to a person solely on the ground of that person belonging to a particular religion. Secular laws are basically legislations enacted by the Parliament on marriage and divorce which are not specific to any religion and can be made applicable to a citizen irrespective of his or her religious status. Personal religious laws apply to persons by default and may be codified or uncodified. Codified means they are written down laws and you can find them within a specific piece of legislation like an act. Most of Hindu personal laws are codified, and the law governing marriages and divorces for Hindus is the Hindu Marriage Act of 1955. Secular legislations do not apply by default, and to be governed by a secular law, persons have to opt for it at the time of their marriage by registering their marriage under the equivalent secular law. For example, Hindus can opt out of the personal Hindu law of the Hindu Marriage Act of 1955 by registering their marriage under the secular Special Marriage Act. The Special Marriage Act of 1954 provides a secular law, and these are of course of particular importance for couples who choose to marry either under a secular framework or when individuals belong to different religious faiths. This section will describe the legislative history of the Hindu Marriage Act of 1955. Dr. B.R. Ambedkar, who had a dominant role in drafting the Indian Constitution, became the first Law Minister of India under Nehru's reign as Prime Minister. Under the Nehru-led government, a committee was formed with Dr. B.R. Ambedkar as its chairperson. This committee was tasked with the role and responsibility to codify Hindu personal laws. The committee formulated and drafted legislative bills which were called the Hindu Code Bill, aimed at codifying Hindu personal laws governing matters of marriage, divorce, adoption, maintenance and custody. The Hindu Code Bill received great opposition from the then President of India, Dr. Prasad, and several congressmen. Many people saw the Hindu Code Bill as an intrusion into their religion. Some radical Hindus thought that the Hindu Code Bill would drastically reform Hindu personal laws, while some Hindu Dalits did not consider themselves as Hindus. Due to the impending elections, the Nehru government decided to defer the agenda regarding the development of the Hindu Code Bill. It feared that due to such opposition and deferment, they might lose upcoming elections. Due to this, Dr. B.R. Ambedkar resigned in protest in 1951, and the Hindu Code Bill lapsed due to re-elections. In 1952, the then Law Minister C.C. Biswas moved the Parliament for passing of the Hindu Code Bill. The members of the Parliament realised that it was an impossible task to pass and enact the Hindu Code Bill as one whole, and thus divided it into three separate bills. First, the Hindu Marriage and Divorce Bill. Second, the Hindu Adoption and Maintenance Bill. And third, the Hindu Succession Bill. The Hindu Code Bill was finally enacted in 1955 to 1956. The Hindu Marriage Act 1955, that earlier formed part of the Hindu Code Bill, was now enacted to amend and codify marriage and divorce laws between Hindus, thus hoping to make them consistent across the country. As mentioned earlier, the Hindu Marriage Act of 1955, being a codification of Hindu personal law, was made applicable and is applicable not to all citizens of India, but only to Hindu citizens. The applicability of the Hindu Marriage Act 1955 is wider than it appears, as it also appears to all Indic religions, including Sikhs, Jains, Buddhists. Section 2 of the Hindu Marriage Act 1955 explicitly makes the Hindu Marriage Act applicable to Sikhs, Jains and Buddhists. Though there were objections raised in Parliament against such wide applicability, the Hindu Marriage Act law, when it was passed, continued to carry with it Section 2. Till date, many authors and citizens from the communities of Sikhs, Jains and Buddhists criticise Section 2 of the Hindu Marriage Act. They say that its applicability to minority religions is unfair, and they see this law as an intrusion into their religious affairs. It is important to note that the Hindu Marriage Act also is applicable to any person who has converted or reconverted to be a Hindu, Buddhist, Jain or Sikh. The Hindu Marriage Act is also applicable to legitimate and illegitimate children where either both or one of the parents are a Hindu, Buddhist, Jain or Sikh by religion, or where one of the parents follows one of the same religions and who is brought up as a member of a tribe, community or a group or family to which such parents belong or have belonged in the past. By virtue of Section 4 of the Hindu Marriage Act, this codified piece of Hindu personal law overrides any uncodified Hindu personal law that run contrary to its codified provisions. The Hindu Marriage Act therefore tries to create consistency across the state of India, and it forms the sole source of Hindu personal law on marriages and divorce. Section 5 of the Act specifies the conditions that must be met for a valid Hindu marriage. A valid marriage between two Hindus is considered as valid if the following conditions are met. 1. Neither party has a spouse living at the time of the marriage. Bigamy is prohibited under Section 17 of the Hindu Marriage Act. It is also a punishable offence under Sections 494 and 495 of the Indian Penal Code. Second, at the time of the marriage, neither party must be incapable of giving valid consent of the marriage in consequence of unsoundness of mind, or, though capable of giving a valid consent, has been suffering from a mental disorder of such a kind or to such an extent as to be unfit for marriage and for procreation of children, or if a person has been subjected to recurrent attacks of insanity or epilepsy. The third condition for a valid marriage is that the bridegroom has completed the age of 21 years and the bride has completed the age of 18 at the time of the marriage ceremony. Fourth, the parties are not within the degrees of a prohibited relationship, for example, a close blood relation, unless the custom or usage governing each of them permits a marriage between the two. Fifth, the parties are not sapinders of each other, unless the custom or usage governing each of them permits a marriage between the two. Section 7 of the Hindu Marriage Act states that a Hindu marriage is solemnized when undertaken in accordance with the customary rites and rituals prescribed by their religion, and the ceremonies of either party thereto. The majority of Hindu marriages require 7 steps of the couple jointly around a sacred fire for the marriage to be solemnized. Under Section 18 of the Hindu Marriage Act, failure to meet certain conditions to marriage prescribed under Section 5 of the Act may lead to a punishment in the form of a simple imprisonment, which may extend to 1 month, or with a fine which may extend to 1,000 rupees. Alternatively, they could be given both a prison sentence and a fine. If conditions mentioned under Section 5 are not met, the marriage is either void or voidable. This is codified under Sections 11, 12 and 17 of the Hindu Marriage Act. A void marriage is a marriage that has no legal status from the commencement, and a voidable marriage is a marriage that has a legal status until the time the court passes a decree of annulment. If conditions 1, 4 and 5, as listed above, are not met, then the marriage will be void. If condition 2 is not met, the marriage will be voidable. Further, if the bride is pregnant with a child of another man, or the marriage is not consummated due to impotency, then the marriage can be declared voidable. Section 8 of the Hindu Marriage Act 1955 provides for registration of marriage, but such registration is not mandatory, and failure to register a marriage does not make the marriage invalid. Registration of a marriage leads to an entry into the particulars of the marriage in the Hindu Marriage Register. This register is maintained by state authorities. The registration serves as evidence that the marriage has taken place. Some state legislatures have amended Section 8 of the Hindu Marriage Act and made rules for registration. The Supreme Court of India and the High Courts have recommended that registration of marriages should be made compulsory. The Hindu Marriage Act of 1955 entitles both the husband and a wife to file a petition before the courts of law for divorce. A divorce petition can only be filed in a court of law after 1 year since the date of the marriage has elapsed. The reason behind this is that marriages in Hinduism are considered to be sacred, and it is believed that the couple should make all reasonable attempts to make the marriage work. This focus on trying to make marriages work means that only in exceptional cases courts of law may admit a petition before the completion of 1 year of marriage has been completed. A petition for divorce shall be presented to the district court within the local limits of whose ordinary original civil jurisdiction the marriage was solemnized within. Secondly, a respondent at the time of the presentation of the petition resides, or the couple to the marriage last resided in together. A divorce petition may also be submitted to a district court if the petitioner is residing in that district at the time of the presentation of the petition, or in a case where the respondent is living there at the time and residing outside the territories to which the Hindu Marriage Act typically extends, or has not been heard of as being alive for a period of 7 years or more by the persons who would naturally have heard of him if he were alive. Further, Section 23 of the Hindu Marriage Act mandates the courts of law to, before granting any relief under the Act, endeavour to bring about a reconciliation between the parties and refer the matter for reconciliation to be undertaken within a reasonably stipulated time period. However, this duty of the courts of law is not applicable if relief is sought on any of the grounds specified in Section 13(1) clauses 2 to 7. The grounds include conversion to another religion, unsoundness of mind, a husband missing for 7 years, incurable disease, or a renouncement of the world. A Hindu may petition for divorce on the following grounds as prescribed under Section 13, clauses 1a and 2. Adultery, when a husband or wife has had voluntary sexual intercourse with another man or another woman, or cruelty, where the husband or wife has suffered physically or mentally from abuse. Desertion, where the husband or wife has been deserted for a continuous period of not less than 2 years. And conversion to another religion, where the husband or wife has ceased to be a Hindu and has adopted another religion and all of its faith elements. A couple may also file for divorce if either the husband or wife has been diagnosed as having unsoundness of mind since the marriage ceremony took place. This unsoundness of mind to such an extent should interfere with the normal married life and make the marriage no longer possible. Disease of the husband or wife has also been diagnosed with an incurable form of leprosy or has a form of venereal disease in a communicable form. Presumption of death of the husband or wife, and where the husband or wife has not been seen alive for 7 years or more, will also be grounds for divorce. No resumption of cohabitation between the husband and wife after a decree of judicial separation for a period of at least 1 year. Further, a wife may seek a divorce also under Section 13(2) on the grounds that another wife of the husband was alive at the time of the marriage ceremony, or the husband has been convicted of a rape, sodomy, or bestiality, or cohabitation has not been resumed within a period after an order for maintenance under Section 125 of the Criminal Code of Procedure, or, alternatively, under the Hindu Adoption and Maintenance Act. The wife may also file for a petition of divorce if the wife was not a major when she married and wishes to repudiate the marriage before attaining the age of 18. Pursuant to Section 13b of the Hindu Marriage Act, both a husband and wife together can claim divorce on the grounds of mutual consent. The Supreme Court in 2006 recommended to the Union of India that it should amend its Hindu Marriage Act to incorporate another ground for divorce in the following words. Before we part with this case, on the consideration of the totality of facts, this court would like to recommend the Union of India to seriously consider bringing an amendment into the Hindu Marriage Act 1955 to incorporate irretrievable breakdown of marriage as a ground of divorce. A copy of this judgment was sent to the Secretary, Ministry of Law and Justice Department of Legal Affairs in the Government of India for their consideration. The court also hoped that they would take appropriate steps to amend the Hindu Marriage Act. The Law Commission of India has explained irretrievable breakdown of marriage as follows: a ground which the court can examine, and if the court, on the facts of the case, comes to the conclusion that the marriage cannot be repaired or saved, divorce can be granted. The grant of divorce is not dependent on the volition of the parties, but on the court coming to the conclusion on the facts pleaded that the marriage has irretrievably broken down. Irretrievable breakdown of marriage is a recognised ground for divorce in countries like New Zealand and the United Kingdom. Despite there being no law on irretrievable breakdown of marriage, in another 2006 case, the Supreme Court of India, while granting a divorce, ruled as follows. We are fully convinced that the marriage between the parties has irretrievably broken down because of incompatibility of temperament. In fact, there has been total disappearance of emotional substratum in the marriage. The matrimonial bond between the parties is beyond repair, and that the marriage has been wrecked beyond the hope of salvage, and therefore public interest and interest of all concerned lies in the recognition of the fact and to declare defunct de jure what is already defunct de facto. Even as far back as in 1996, the Supreme Court of India, in the absence of a law on irretrievable breakdown of marriage, ruled that the marriage between the appellant and the respondent has irretrievably broken down, and that there was no possibility of reconciliation. We, in exercise of our powers under Article 142 of the Constitution of India, hereby direct that the marriage between the appellant and the respondent shall stand dissolved by a decree of divorce. In 2013, a Marriage Laws Amendment Bill was introduced and passed in the Rajya Sabha to amend the Hindu Marriage Act. This amendment was intended to incorporate irretrievable breakdown of marriage as a ground for seeking divorce. The bill was not taken up by the Lok Sabha, and this, therefore, did not become law. A Hindu who has been divorced can marry again once the divorce has been finalised. That is, once the period of filing an appeal against the divorce has expired, or the appeal, having been filed, has been dismissed. The courts of law can, using their discretion, treat a petition for divorce as one for judicial separation. Judicial separation means that a couple is living separately pursuant to a court order being passed, but are still married. Such a court order can be procured by the husband or wife by filing a petition praying for a decree of judicial separation on any of the grounds specified in Section 13(1) and 13(2). Under Section 28 of the Hindu Marriage Act 1955, a court decree granting or refusing divorce are appealable by both a husband and a wife, whoever is unsatisfied with the court decree within 30 days. It is important to note that a court decree is not automatically enforceable. Pursuant to Section 28 of the Hindu Marriage Act, all court decrees and orders in marriage or divorce proceedings shall be enforced in the like manner as the court decrees, and orders made in the exercise of its original civil jurisdiction for the time being are enforced. This means that the position that stands today is that Hindu personal laws are in a codified form. There exist enacted legislations on matters of Hindu marriage, divorce, adoption, and succession and maintenance. The advantage of having Hindu personal laws codified is that the chances of misuse of Hindu personal laws is supposed to decrease. It is therefore claimed that cases of misuse are relatively lower as the codified legislations are explicit and clear in their language. Also, divorce being a court-driven process prevents divorce from being given on the grounds other than those that are reasonable. Issues such as maintenance and custody, which often form an integral part of divorce, will be examined in a separate module. The following module will examine marriage and divorce laws under Muslim and other personal laws. This marks the end of this module. Thank you.